Good afternoon, everyone. Thank you so much for being with us this afternoon. I would like to welcome everyone to our webinar on blended families, common legal issues for new and former step-parents, which is hosted by METRAC, Action on Violence, with our guest speaker, Valerie Dye, who is a lawyer from Dye Law. My name is Andrea Collins Fitzpatrick, and I'm the legal director for METRAC's Community Justice Program. I would like to start with a disclaimer by reminding you that this webinar is for general information purposes only and is not legal advice. The legal information provided is not intended to be used as legal advice for a specific legal problem. I'd just like to let you know that this webinar will be recorded and reflects developments in the law before today, November 9th, 2023. It will be posted on our website at onefamilylaw.ca, one.familylaw.ca, along with the PowerPoint slides. I would like to begin today with a land acknowledgement. We acknowledge that this land is the traditional territory of many nations, including the Huron-Wendat, Haudenosaunee, and the Mississaugas of the Credit. Today, the meeting place of Toronto is still home to many Indigenous people. We honor all the First Nation, Métis, and Inuit people living on this land. We recognize the traditional territories on which our organization is located and on which our programs and trainings take place. Before I move to our presenter today, I would like to tell you a bit about METRAC. Some of you may know, because you've been to our webinars before, METRAC works to end gender-based violence, and we have been in existence since 1984. Our programs are devoted to advancing safety, justice, and equity. METRAC's Community Justice Program provides legal education and information related to gender-based violence. Through our Access to Justice program, we provide legal information in areas of family law, immigration law, criminal law, employment law, and human rights law. This webinar is part of our Family Law Education for Women, FLU series. FLU's resources are available in 14 languages, ASL videos, and accessible formats. You can visit our website at onefamilylaw.ca, onefamilylaw.ca, for more information on your family law matters. So I'm very excited today to have Valerie Dye to speak to us today about blended families and the common legal issues that we will face. Valerie Dye is a sole practitioner at Dye Law. Her practice focuses mainly on family law, real estate, and wills and estate. Valerie has taught business law at Toronto Metropolitan University, as it's now known as a session instructor. Valerie was first admitted to practice law in Guyana when she practiced briefly before moving to St. Kitts and Nevis, where she works as Crown Counsel for the Ministry of the Attorney General. She later attended the University of Manchester in the United Kingdom, where she obtained an LLM and a PhD in law, and where she also taught for a number of years. Valerie also taught at the University of Liverpool online LLM program. She was called to the Ontario Bar in 2013 and has been in sole practice since 2014. I'd just like to remind you that we will have a Q&A after the presentation. If you have any questions, please post them in the chat. We will also have a survey that we would please like you to fill out, and it will be posted in the chat towards the end of the presentation. I'd also like to thank Kenny Yan, who is doing our slides, and Ferdinand, who is our sound technician today. So please enjoy the presentation, and thank you again for being here. I'll now pass things on to Valerie. Thanks, Valerie.
Thank you very much, Andrea. Thank you for your introduction. And I'm very pleased to be here again. I think I did a presentation about 2 years ago. It didn't seem that long, but I was just told that it was 2 years ago. And so I'm happy to be here again to talk to you about blended families and legal issues that affect new and former step-parents. And so I'll start by mentioning what is meant by a blended family. And a blended family is basically a family where either or both spouses have children from a previous relationship. So it can be the woman may have been married before, or not necessarily married. She may simply have had children from relationship before, and she comes into a relationship with a man, or the other person may have had children before, or both of them may have had children before. But regardless of either party bringing children to that relationship, that is now a blended family, because the children will not be the children of both of the parties. And so when we're dealing with blended families, there are a number of issues. In fact, there are quite a number of issues to consider. One of them would be support for stepchildren. in the event of a separation, because of course, oftentimes blended families may not work out. And if the children are below a certain age, or if they're still dependents, you would have the issue of whether or not the non-biological parent should pay child support. So that's one issue. There are also financial issues dealing with what each person brings to the marriage. I say marriage, but I should really say relationship, because this is not limited only to when parties are married. It also relates to common law spouses. So financial issues will come about regarding what each person brings to the marriage or to the relationship, how those should be utilized, how those should be divided, tax planning, family law planning, and estate planning. So we will not be touching on all of these today. And of course, there are other issues that I haven't mentioned, but we will not deal with all of these today. What we will deal with mainly today would be the issue of support. We will look at estate matters. We will look at marriage contract. And then, of course, whatever I don't mention, you'll have an opportunity to ask questions at the end as it relates to blended families. Okay? So when you're in a blended family, some of the things you want to make sure of is that your minor children will be supported in the event that there's a separation. You also want to make sure that in the event of your death, both your children and your surviving spouse benefit from your estate. And of course, if you don't plan carefully, you may have undesirable results. You may think that when you die, your assets will go to your children, but if you don't plan carefully, that may not happen. So it's very, very important. I know lots of people overlook that issue. They carry on in a relationship, they have children from a former union, and they just take things for granted, and then they die or someone else dies, and there's lots of confusion. So these issues should be considered. So let's talk about the issue of child support. That's one of the main issues when there's separation in a blended family. Lots of people think these are not my biological children. Yes, they were in the family, and they were part of the family. They ate the food. We were part of the family, but because they're not my biological children, now that we're separated, I have no business with them. Their welfare is not my issue because they're not my biological children. Wrong. The law says that step-parents may be liable for support as regards to children in a blended family. So you can only be liable for support if there's one basic element that exists. And that element is referred to as loco parentis. It's a Latin word, and it simply means, has the spouse acted as a parent to that child? So before we get to the issue of whether or not a separated spouse who came from a blended family should support children that, non-biological children, the main issue to consider is, was that parent in loco parentis? Did that parent accept that child as their own child? And that acceptance does not have to be in writing. It does not have to be verbalized. It's simply the way you would have acted when you were in that relationship with the other party. Okay? So if it is found that you acted as a parent, then the issue of child support will arise. How do you establish that? How do you establish whether someone has acted as a parent to a child that is not theirs? Some of the issues the court will look at include whether the child participates in the extended family in the same way as a biological child would participate. For instance, do you have family gatherings and that child is involved in the family gathering? Do you go on vacation as a family and that child is included? Do you spend Christmas Day at your family and your non-biological child comes along with the rest of the family to be part of that Christmas vacation? So that's a crucial question. Has that child participated in that family in the same way as your non-biological children? Another issue is whether the non-biological parent provides financially for the child. For instance, you're bringing in a paycheck every month and your spouse is depending on that paycheck to feed the family. And obviously, if that child that is not yours is part of the family, is he being treated in the same way? He eats the food, the money is used to buy clothing for all the children, school supplies. And so financially, that child benefits from the non-biological parent in the same way as the other children. And even if there are no other children, if it's only that non-biological child in that family, is that child being treated as if he or she is a child of both parties? Another issue that the court might look at is whether the non-biological parent disciplines the child in the way a regular parent does. Okay? Another issue would be whether you present to the world or to the child that you are a parent. You may give the child the impression that you are a parent. The way you treat the child, you may buy him things. You may, talk to him in a way a parent talks to a child. You may represent to the teachers that you're standing in the place of a parent. The teachers may see you as a parent. Neighbors and other parties may see you as a parent, as someone standing in the place of a parent. Okay, so that's another issue. Another issue that the courts will consider is the nature or the existence of the child's relationship with the absent biological father. Now, I'll say a little bit more about this later. Now, this is not an exhaustive list. I mean, it's not a one size fits all. The court will generally look at the entire picture and make a decision as to whether or not a particular spouse is standing in the place of a parent. Okay? Now, I just mentioned as one of the criteria the nature and existence of the child's relationship with the absent biological parent. Now, that still is not conclusive because it doesn't matter if the biological parent is also involved in the child's life. For instance, the biological parent may be seeing that child perhaps every weekend or every other weekend, or as the case may be, once per month, whatever arrangement is put in place. So that child still has a relationship with his or her biological parent. That does not mean that the non-biological parent will not be found to be acting as a parent. As I said, the court will look at the entire picture. The child could be benefiting from having both parents in his or her life. So what the courts will look at is the intention of the parties and the intention of the child. And of course, the court is not going to say, well, Jim, what was your intention? The court doesn't ask persons what their intention is. Intention is gathered from the way you have acted. That's the way you know someone's intention. Because if you ask them after they separate, was it your intention to treat this child as your own? They're going to say no because they don't want to pay support. So the court will look at intention that is garnered through the way you have acted during the relationship. Okay, and then how the child feels towards you. Anything that will show that there has been some relationship of dependency. Okay. Now, one thing that happens regularly, and I can think of one particular case, is a child may be in a home and everything is fine. The non-biological parent treats that child as his or her child. And then there's a separation and the non-biological child goes away, lives separately. And at that point in time, that non-biological parent severs all contact with the with the non-biological child, and at that point starts treating the child like a stranger, when this is not what was happening when the relationship was going well. But it starts happening after the relationship has broken, and they start treating that child as if that child is not their own, treating that child as if that child is a stranger. And then they go to court and they try to make a case that they don't have a parental relationship with that child. Again, this is not what the court looks at, because from the court's perspective, the relationship of loco parentis is determined at the time the family function as a unit. And so if there's a lack of contact after the parents separate, this does not affect the claim for support. So you can decide, non-biological parent can decide, let me keep my distance because I don't want to pay support for this child. The court will not accept that. The court looks at what happened when the relationship was functioning as a family unit. Okay? So having determined, let's say the court determines that a party has acted as a parent, a party has stood in loco parentis, then the next issue that the court moves on to is whether support should be paid. It's not conclusive yet. It depends on other circumstances. And if support should be paid, how much support should be paid? Now, generally, when you have children and you're separated and you have to pay child support, that is governed by Section 3 of the Federal Support Guidelines. And Section 3 of the Federal Support Guidelines simply states, to put it simply, you pay child support based on your earnings. So obviously, if you earn $100,000 per year, you will pay more child support than someone who earns $50,000 per year. And again, it depends on the number of children. So if you're earning $100,000 per year and you're paying for 5 children, obviously you'll be paying more than you will pay if you're earning $100,000 and you're only paying for 1 child. So under Section 3 for your biological children, the court looks at your earnings. For non-biological parents who stand in the place of a parent, they're governed by Section 5 of the Federal Support Guideline. And Section 5 says, where the spouse against whom a child support order is sought stands in the place of a parent for a child, the amount of child support order is, in respect of that spouse, such amount as the court considers appropriate, having regard to these guidelines and any other parent's legal duty to support child. To break that down, what they're simply saying is that the court has a discretion. They will award an appropriate amount and they will look at various things. So whereas for a biological parent, you pay according to what you earn, the only time the court does not do that for a biological parent is if you claim hardship. If you claim hardship, let's say you have 10 other children and you have medical issues and you don't earn lots of money, that's the only time the court will vary from Section 3 for your own biological children. But generally, you pay depending on what you earn. But for Section 5, the court has a discretion and they will award an appropriate amount based on perhaps the guidelines, and there might be another parent who also has a duty to support that non-biological child. Another important thing to note, and the court also considers this, remember we said the court has a discretion. So one of the things the court considers is that you may be a step parent to, let's say, Annie. Annie has a biological father who pays support for her. He may be paying $300 a month. And it is normal for the non-biological parent to think, well, I should not have to pay support for Annie because Annie gets support from her biological parent. No, the court, it does not automatically mean that because the biological parent pays support, that the non-biological parent will not pay support. Because here's one scenario. Annie may be getting child support from her dad, Jim, but Jim is only paying $300 per month. When Annie lived with you, you might have been a high income earner and Annie might have been accustomed to a certain type of lifestyle. now you're separated from Annie's mom, and Annie only now has that $300 that she gets from her biological father. And of course, her mom does not earn that much. So her standard of living goes right down. Now, the court does not like that. The court will try as much as possible to allow that child to maintain a certain standard of living. And so, even though Annie may be getting support from her dad, it's very likely, especially if you're a high income earner, it is very likely that the court will say, okay, Annie's dad is paying 300, you should top that up with another 300, maybe 500. The court will look at the scenarios and determine how much you should pay. So it not because Annie gets support from her dad, it means that her stepdad will not have to pay support. The court will look at all the circumstances, the needs of the child, and the amount of support that Annie gets. Now, I was reading one case earlier today where the court established loco parentis. The stepdad tried to deny that he stood in the place of a parent, but the court found that he did stand in the place of the parent, regardless of what he was saying. However, he earned annually $48,000, whereas the biological parent earned about $90,000. And so even though he stood in the place of a parent, the court didn't think it would have been fair to ask him to pay additional child support on top of what the child was getting from their biological parent. So it depends on the circumstances. If they're able to top up what the biological parent is paying, then the court will award that. If the biological parent pays nothing at all, then they will have to pay support. Okay? But one thing to remember, it is not necessarily tied to how much you earn in the same way as if it were your biological child. Okay, so that ends what we will discuss for child support for a non-biological parent. And we'll move on to talk a bit about estate planning for a blended family. And one of the main issues is how can you ensure that your children, as well as your spouse, benefit from your estate after you pass on? Now, here are two scenarios. You may be married and you own property jointly with your spouse. You have children from a previous union. Your spouse may also have children from a previous union. Now, the right of survivorship may prevent your children from inheriting your property after you die if you don't plan carefully. If you fail to make a will, for instance, this can lead to intestacy, which may lead to undesirable results. Now, if you're in a blended family and you have property, you have children, your partner has children, there are certain options that you have, because it's important to do estate planning. I know lots of us, especially younger people, don't see the need to do estate planning, but people can die at any age, and it's extremely important to address your minds to what will happen to your children and to your spouse in the event that you should die young or whether you die old. It doesn't matter. We don't know when you will die. So one of the options we have is to do mutual wills. And here is how that works. You will do a will saying the property that you have might not only be real property, it could be investments, it could be money in the bank. You may decide, okay, I will do a will to say that half of what I have goes to my children and half of what I have goes to his children. And the agreement will be that he will do the will to say the same thing. So you have mutual wills that say the same thing, so that when you die, you expect that he will follow through with his will. Now, there's a problem with mutual wills. One of the problems is that after the death of one spouse, the other spouse can revoke his will, because a will can can be revoked at any time. So you have mutual wills. You both agree that you're leaving your assets part to your children and part to his children, and then you die, and he decides to revoke the will. And so your wishes are not put into place. What some lawyers do to avoid that is that they do something called a will contract, whereby they make the parties sign a contract saying that they will not revoke their will. That too is not very advisable. One, because the contract could be misplaced, and two, they can sell the property and then your relatives try to enforce that contract and they can't enforce it because the property no longer exists. So mutual wills is one option, but it's not the best option. So let's look at other options to protect your children and your spouse. Now, before I look at what you can do, let's explain how you can hold property, how you can own property. In Canada and in most common law countries, you can own property either jointly or as joint tenants, that's one way, or you can own property as tenants in common, meaning that you own 50% and your partner owns 50%. So how it will appear on the deed is that it can say, for instance, Jim and Maria as joint tenants. Or it can say Jim 50% and Maria 50%. But most married couples own property as joint tenants or jointly. What that means is that if Jim and Maria own property jointly, when Jim dies, Maria automatically owns the entire property. If Maria dies before Jim, Jim automatically owns the entire property. What does that mean if you have children from a previous union that you want to provide for? What it means is that Jim dies, Maria owns the entire property. And once Maria owns the entire property, especially if she has children, what do you think will be the natural thing for Maria to do? She can say, this is now my property. This is solely my property. I will leave it for my children. So even though Jim was originally a part owner, he is dead and his children get nothing because Maria now owns the whole property and she passes it on to her children. Or Maria might get married again, have another spouse. She may have more children. Any number of things can happen simply because the property is held jointly. And I'm not saying don't own property jointly, but there are things that you can do to prevent your children from being disinherited. Now, one of the things that you can do, which again, now remember when we talk about these things, it's not a one size fit all. Everything depends on your particular circumstances. And I know this one has worked and does work for some people. Jim and Maria, I'm just using those two names. Jim and Maria, let's say Jim has 2 children and Maria has 1. What they can decide to do is to add the names of these children to their property. That depends on their ages and that depends on their circumstances. It will only work if the circumstance is right. So if they add that, then all 5 of them will be joint owners of this property. And as soon as one dies, the survivors own the property. And so it goes on like that. And after Jim and Maria die, it's owned by all their children, and then they can decide to sell it and divide the proceeds. Now, this has limitations. It's a very good strategy, but it has limitations. And one of the limitations is that any one of the owner can force the sale of the property. Secondly, if the property still has a mortgage, then all the owners of the property will need to qualify to get a new mortgage if the mortgage has to be renewed. Everyone who owns the property. Thirdly, let's say one of Jim's son or Maria's son or somebody's child has a judgment against them. They owe money and someone takes them to court and there's a judgment of, say, $50,000. Then that judgment will be registered on the property and there will be a lien on that property. And so those are the reasons why, even though this is a good strategy, you have to know your children and know whether this will be okay with you. If you have one child who you know will not have a judgment against them, or who you're confident they will sign for the mortgage to be renewed, if you have confidence in your child or your children, then this strategy works. But you'll have to examine and determine whether this will work for you. What are some of the options that you have if you have property that is owned with you and your spouse? And that is if both of you have children. Apart from adding their names to the property, you should change that property from ownership jointly to ownership as 50-50. So Jim and Maria can decide to do a transfer, and instead of saying they own the property jointly, they can decide that, okay, we'll transfer it and we'll own it in such a way that it states that Jim owns 50% and Maria owns 50%. When that happens, Jim can make a will and leave his 50% for his children, and Maria can make a will and leave her 50% for her children. Because I didn't mention this before, if you own property jointly, it doesn't matter if you put in your will that your share goes to your children. As long as it is owned jointly, it passes outside of the will. It goes to the other joint owner. But when you divide it 50-50, then you can make a will and say your 50% goes to your children and the other party's 50% goes to their children. Now, another thing you can do is to leave money in an investment, in a trust, and ensure that, when you die, your spouse will get the income from that investment. And then when your spouse dies, that investment goes to your children. Now, another scenario that happens is that you may leave your 50% of your property for your children, and your children inherit that 50%. So now they own that 50% along with the surviving spouse. Guess what they can do? They can go to court and they can say, well, we are part owner of this property and we want it sold. And there is in the legislation, the court, anyone who owns a property can force a sale. So the children can say, we want this property sold. We don't care about our stepmom or our stepdad. We are entitled to have the property sold. Now, of course, the surviving spouse can buy their share, but if he or she cannot afford to buy it, then the property will be sold. How can you prevent that? You can, in your will, you can say that the 50% goes to your children, but your spouse is entitled to live in that house until your spouse dies. And at that time, at the time of that spouse death, only then can your children get their 50%. So in that way, you protect your spouse from being left without a home. As I said before, one of the best solutions is to split the joint tenancy to ensure that it's owned 50-50. Another way you can provide for your children or your spouse, now there are times when parties don't have enough assets to leave, for both their children and their spouse. So what they can do, and I would strongly advise persons to do this, is to take out a life insurance, and so that when you die, your children will benefit from the proceeds of your life insurance. And this is also helpful if you have children who are almost the same age as your spouse, because you may decide, okay, I'm making my will so that my spouse will live in this house until my spouse dies, and then my children will get it. But what if your spouse and your children are almost the same age? Because some persons have spouses that are much younger than they are. In that case, the children will not have a chance to enjoy the house as much as they should. So in that case, it may be good to have insurance that your children will benefit from once you die, and or have other assets that will pass on to your children. Now, if you have minor children and you take out a life insurance, it is important to leave someone as a trustee who will manage the money from the life insurance until your children get to the age of majority. Okay? The next part of what I will talk about, and I hope you're saving your questions so that we will discuss them at the end. Let's talk about domestic contracts. Under Section 51 of the Family Law Act, parties can enter into a domestic contract, which will govern the way they deal with their assets, which will govern the way they deal with their relationship. It will also govern the way they deal with support. And domestic contracts could be one of three types. It can be a marriage contract, which you enter into when you're about to get married, but not only when you're about to get married. You can be married already, and you may think it's best to have a marriage contract. Even if you've been married, 1 or 2 years or however many years, you can still have a marriage contract. If you're not married, but you're in common law, you can have what is called a cohabitation agreement. Or if you are separating, you can have what is called a separation agreement. Now, all of these agreements are governed by Section 51, between Section 51 and Section 56 of the Family Law Act. And these agreements have as much weight as a court order, so that if they're not followed, you can sue the other person for breaching that agreement. But the main thing about having a domestic contract is that you're not depending on legislation to determine how you deal with your issues. For instance, if you're married and you separate, you have to go through a process of equalization, meaning that the court will divide up your assets. To put it simply, they will look at your net worth and your partner's net worth, and the person that has a higher net worth will have to pay half of the difference to the other party so that you come out on the same footing. That's called equalization. And it's important to note as well, and lots of people don't know this, people own homes when they're single, and then they get married and they move their new partner into that home. And lots of people think that, oh, I've had this before marriage, so it will not be divided. The thing is that as long as that home becomes a matrimonial home, then it has to be divided. If you had a home before, and I know one young man who had a home before and he got married, but he was very wise. He rented out that house, and he and his new wife they moved into rented premises. So the home that he had never became a matrimonial home. So if you have a home before and it does not become a matrimonial home, you do not have to divide it. But as long as that home becomes a matrimonial home, doesn't matter how long you've had it before your marriage, it has to be divided. But that's the reason why you need to do a marriage contract, because in your marriage contract, you can stipulate that whatever you had before will not be divided, in accordance with the law. You will want all your property issues to be determined in accordance with what is mentioned in the marriage contract. So it's very important to know that. Now, the same thing with the cohabitation agreement. But let's talk about the marriage contract a little bit more. Although you can have a marriage contract that governs what happens, in the event of a breakdown of marriage, some provisions in the marriage contract it can succeed. In other words, it will still be relevant after you die, so that you can make provisions that are binding on the estate of the other party. For instance, you can say, if I die, my spouse should not benefit from my estate except to the extent that I put in my will, or except to a certain extent. So you can say that you don't want your spouse to benefit from your estate. You can say that there'll be no claim for spousal support. You can say that there'll be no equalization. So those are some of the things you can put in your marriage contract. Now, basically, courts uphold your contract, your marriage contract, for the most part, but there are certain provisions that the court will not uphold. And one of those provisions is a provision related to child support. They may uphold it, they will uphold it, obviously, if you state the provision in the contract to be in accordance with what you should pay according to your earnings. They will uphold that. But let's say you earn 100,000 per year, and in the marriage contract, you say that in the event of a breakdown, I will only pay child support of $200 per month. The court's not going to uphold that. The contract will be valid, but that particular part of the contract, the court will not uphold that. Because the court is basically guided by what is best for the child. And the court will never allow a clause in a contract that allows someone to underpay child support. Okay, so that provision will not be upheld. Another provision that will not be upheld in the contract is if you say that one party will have no rights to the matrimonial home in the case of separation. That will not be upheld. The court will strike that part down. So let's talk a little bit about cohabitation agreements. I don't think that it's in the slide there, but I think I need to mention it a little bit. Cohabitation agreements, those are important because parties may live together as common law. And of course, you're not subject to the same rights as married couples in terms of how your property is divided. However, and I've seen this quite a number of times, persons live together as common law for a number of years, 10 years, 11 years, 12 years. And lots of people think that they have the same rights as common law couples as they have as married couples. And then they separate and discover that they don't have the same rights. Now, if you are married, it does not matter whether you contributed towards the purchase of the matrimonial home. You are still entitled to a part of it if there's a separation. If you are common law, you are not. The only way you are entitled to a part of that home is if you prove that you've contributed to the acquisition of that home. You have to show that you paid money towards the deposit. Even if you didn't pay money towards the deposit, you may have to show that you did repairs or what have you. You must show that there has been some contribution. Now, under the cohabitation agreement, you may want to specify that anything acquired during the union will belong to both of you, regardless of who contributes, because that doesn't happen outside of that agreement. So you may want to specify that, or you may want to specify that we only own what we purchase, as the case may be. So it's important to know that. Separation agreements as well are important. To my mind, the main importance of the separation agreement is that it prevents you from going through the stress of fighting things out in court and dealing with drawn out court cases. Now, if parties are able to talk things through and to discuss things, they can enter into a separation agreement. This can be filed in court. You can even make provisions for support, which will be filed with the Family Responsibility Office and will be enforced with them. And so you do not have to go through a long court process to determine your rights. Okay? So in conclusion, plan carefully, bearing your own circumstances in mind. Know that if you're getting married and you're having a blended family with stepchildren, go into it knowing that you may be liable to pay child support in the event of a breakdown of marriage. Plan knowing that one size does not fit all. Something may work for one party. It does not mean it will work for you, especially in terms of property issues. It depends on your circumstance. And so it's important to discuss with a lawyer what are your best options. And then finally, if you own property as joint tenants or jointly, make sure you understand the implications of that, especially if you have children from a former union. You don't want your children to be disinherited, because if you own property jointly with your spouse and you die, that property goes entirely to your spouse. Your children will get nothing. Even if you make a will and you say that your share will go to your children, they still will get nothing because the property is jointly owned. So consider, in that case, owning your property 50-50, not jointly. Okay? I hope what I've said has been very informative, and now I look forward to your questions. I'll try to answer them as best as I can.
Thank you so much, Valerie. That was very, very informative. I learned so much this afternoon.